Boom. Hey, folks. I hope everyone's doing well. It's been a bit of a crazy day. StreamYard is still having a normal one. StreamYard is not doing, I don't know what StreamYard is up to. It is showing me that there are 0 people here. So I see at least some people in the chat. I assume you're not 0 people. Yeah, StreamYard is doing a weird thing. I don't know what the deal is with StreamYard, but it is what it is. So there were some people wondering, is Mrs. Runkle okay? Mrs. Runkle is fine. I just had to take her to the airport. So she is now, as of right now, she'll be waiting in the airport lounge. Don't go say hi if you know who she is. She probably would be freaked out a bit by that, but she'll be boarding a plane fairly shortly to go on an adventure. I cannot join her on this adventure for a whole bunch of reasons, which is unfortunate. But it means that we get to hang out. I do have a consolation prize. These things, which I think I'm a little bit addicted to, these things are like pretzel bites with peanut butter inside them, and I have been eating the heck out of these. So, yeah, they feel like they should be a dog treat, but they work great as human treats. All right, but we are now going to. This is a great one. Runkle is not high enough level for the DLC that Mrs. Runkle is playing today. That is fair. StreamYard was sold to an Italian company. That would explain it. That would explain what is going on. So, all right, let us have a look at some of the new stuff that's been happening, because for some reason the world just doesn't seem to want to slow down. I don't know what it is. I don't know what's going on right now. The world feels like a fairly crazy place, and cases just keep going and popping off. We've had the Baldwin trial, which has gone completely insane, but we also have the Karen Reed trial, which was completely insane from the outset. The Karen Reed trial was crazy from the beginning, and so it is just going to continue to be crazy. But for some reason, somebody is like throwing gas on the crazy pile, and so we're gonna look at that. There are like 5 documents for us to go through, so we're going to dive in. The good news is that some of these documents are real short documents. So if you got a beer, this is a great time for a beer. I've got I bought these. I'm not super happy with them. This is not really what I wanted. I'm currently drinking the Analog Brewing Fireflower. It's a perfectly serviceable beer. It's perfectly all right. But the main sort of selling point on it was that it actually includes peppers. It includes, amongst other things, Carolina Reapers. And it's just not very spicy. I was hoping for more spice. It's got a little bit of spice. But Analog Brewing is a pretty cool company. They're an Edmonton company. And they're pretty cool because they are total nerds. And yes, I had to work to find these. I actually had to drive all over town to get them. So let's have a look at what we're doing here. We are going to put up, I don't have a particular order for things to go in today. Maybe I'm going to figure out sort of the best order I can, which in some ways is saving some of the best for last, but it just feels like the right order. So we're going to go through, we're going to start with the second supplemental affidavit by Alan Jackson in support of Karen Reed's motion to dismiss. Okay. So, and this is a good idea. Try adding some of your Reaper powder. I totally should. Where is my Reaper powder? My office right now is a giant mess. I don't know what anything is. So where is my Reaper powder? This is not my Reaper powder. This is an F-bomb. All right. So let's go through this. Is this Kennedy's or American law? This is American law right now. Somebody says, please embiggen a bit. There we go. All right. Second supplemental affidavit by Alan Jackson in support of Karen Reid's motion to dismiss. So if you haven't been paying attention as to what's going on here, the Karen Reid trial is basically Karen Reid was accused and she was charged but not convicted of killing her boyfriend, John O'Keefe, Officer John O'Keefe. And the thing is that this is a very, very contentious trial, because depending on your view of this, you either think that Karen Reid is a cold-blooded murderer who totally murdered her boyfriend in a fit of jealous rage, or you think she's been framed by a bunch of bad cops because... And here's the problem. The story, normally I would say framed, is crazy town. Normally I would say that this is the kind of argument you run when you have nothing, less than nothing. Like, normally framed is worse than just arguing we don't know what happened. The thing is that this is one of the weird cases where framed actually seems to have some evidence behind it and actually seems to be a viable theory. So they ran the whole trial and they got to a mistrial. And I've got my Carolina Reaper powder. I am just going to add a little... I'm actually measuring it out on the tip of a knife here, and that's going into my beer. So we're going to see how this goes. I might die. This might be the most metal thing I've ever done, of putting spicy powder on a, into my beer via a knife. So, yeah, we're just going to let that sort of stir itself a little bit. I don't have anything to stir it with. I might have to use a pencil or something. Anyway, so she ran her trial and it ended in a mistrial because of a hung jury. Jury couldn't agree. And the problem is that the judge never actually asked the jurors, hey, how were you voting? Was there anything you were agreed on? Like, were you in agreement on anything there? And so because that was never asked, then that's a problem, right? So now what the defense is saying there was unanimity on counts 1 and 3. So they want those counts to not be able to be pursued again. And so they're filing a series of things. Now, I'm just going to say, I actually think that the odds that they're successful are going to be fairly low. Appeals are always a low chance, but good for them for trying. So let's have a look at what this says. I, Alan Jackson, declare. The first paragraph is just, I am the lawyer for Karen Reid. So on Wednesday, I was contacted by Juror E, true name and identity withheld to maintain anonymity. Based on my conversation with Juror E, etc., 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 I am convinced that Juror E is an actual juror. So this is up to 5, because he's basically said we now have 5 jurors who are confirming the same thing. Juror E stated that he or she decided to contact me to provide information about the results of the jury's decision-making following deliberations. Juror E explained that the jury was unanimous on 1 and 3, that Karen Reid was not guilty of those charges. Juror E then went on to state that the only count on which the jury was deadlocked was in relation to the lower charges on count 2. I took that to mean the lesser included offenses associated with count 2. Juror E indicated that he or she was happy to provide such information, but wished to remain anonymous. Okay, so that's a very short supplemental affidavit, which is nice because we got 5 documents to go through. It is wonderful if we can knock out one document quickly. Next up is also fairly short. and that is Defendant Karen Reed's second supplemental memorandum in support of her motion to dismiss. So now comes the defendant Karen Reed by and through undersigned counsel, and hereby respectfully submits the second supplemental memorandum in support of her motion to dismiss, filed July 8th, 2024. As reflected in the attached affidavit of Alan J. Jackson, a fifth deliberating juror has confirmed that the jury was unanimous on 1 and 3, that Karen Reed was not guilty of those charges. Based on the attached affidavit and all the reasons set forth in its opening motion, first supplemental memorandum and reply, the defense respectfully renews its contention that the jury acquitted Ms. Reed on counts 1 and 3, or alternatively, there was no manifest necessity for a mistrial on those counts, and therefore the double jeopardy protections of the federal and state constitutions require that those counts not be retried. So what do they get out of this? What are they asking for? Because one of the important things as a lawyer is always to know what to ask for and what you should always think about what things you want, right? And I sometimes tell junior lawyers and I tell clients, I'm like, what is your goal here? What is it you want? Because sometimes people have goals that they just can't actually get. One of the really common ones happens in an area of law that I don't practice in. But people who are in employment law, for instance, might sue, and what they want is like a favorable reference. Well, you can't get that through the court. Can't give you that. What the court can give you is money. The court can give you money and potentially lots of money, but they can't give you a favorable reference. So, it's a question like, is that what you want? Is that what your goal is? Sometimes people sue over things that are a little ridiculous. On Monday, one of the things I hope we'll cover, if we are able, if we're able to do a Monday Fun Day, one of the things I hope that we'll be able to go over is a small claims case here in Canada, where somebody sued their former girlfriend to get back the money for a Coldplay ticket. And they're like, I took you to this concert, but it wasn't a gift. It was a loan. I want my money back. Okay, cool. But sometimes people use lawsuits as a way to try to force people back into a relationship with them. That isn't going to happen. Like, that's not going to fly. So, all right. In this case, what they're asking for is they're saying, we want, like, you can retry on count 2. You can retry on that. However, you can't retry on counts 1, which is the murder, or 3, which is the leaving the scene of an accident. And yeah, the judge told the jury not to tell her the vote counts or splits. That's why they didn't tell her not guilty 1 and 3 while hung on 2. They were doing as the judge told them. So, yeah. All right. So what they're asking for here is they're saying, listen, either the court should determine that she was acquitted on those counts, in which case she can't be retried, right? Once you're acquitted, you can't be retried. Or that there was a mistrial, but not a mistrial with a necessity. So it would be a mistrial where there would still be, jeopardy attached, so they can't retry it. Either one of the things that the defense is asking for is basically you can't retry on those. And somebody says, how do you get to guilty on 2 but not 3? I don't know. I don't know how you do that, but it is what it is. The juries can do weird things. So the court notes, if the court would prefer to rule on the basis of affidavits executed directly by the jurors, the defense respectfully requests permission to initiate contact with jurors A, D, and E for the sole purpose of asking them to affirm the accuracy of the 3 affidavits of Alan J. Jackson, i.e., let us talk to the jurors, please, because the court has had some issues on that. All right. So that is sort of the next thing. This is going to get ruled on, and there are some indications that Judge Bev may not be there. We'll see. Dorothea says, are you covering Monday's court hearing? I will cover it, but I won't be able to cover it live. I'm going to cover it in the evening. We're going to do an evening stream, and I'm hoping it's going to be Karen Reed's thing. And also, I'm hoping we can do some Monday Fun Day. Even if it's just a little bit of fun stuff, because we need to have some lighthearted stuff to mix, to offset the bad. Okay, so now we're 2 documents down. That is excellent. I'm going to go through some super chats here. The original Mrs. Rochester, thank you for the membership. Rainman YYC, thank you for the 10 gifted memberships. Much appreciated. Jessica P says, try adding some of your Reaper powder. I've added some. Let's see if it kills me. Not bad. It actually helped. All right, we got a spicy beer. Mildred Katie, surprise Mrs. Runkle with a haircut. I probably should do that. Megan, aka Meg, is autistic. I found chili honey yesterday here in Australia. Ooh, that sounds delightful. Ooh, that's got some burn to it after the fact. Oof. Laura Miller, thank you so much for the new membership. Much appreciated. All right. So, Taro Tempura, watching on 1.5 speed to catch up is a treat because Runkle's ADHD and the speedy speech make him sound a little unhinged. Fair. What did we add Reaper powder to? Beer. It is in a beer. All right. We're going to move on to document number 3. And I'm going to remember this time to show you the document because that seems fair. All right. Let's have a look. Emergency motion of interested non-party juror Doe to extend the order of impoundment of the jury list. And you might be saying, wait a minute. How is a juror a non-party? Well, that's easy, actually, because the parties to this are the Commonwealth of Massachusetts. That's party number 1. And Karen Reed. Literally every other person on the planet is a non-party, including the witnesses, including the witnesses. So, all of the witnesses, all of them are non-parties, including people like Paul O'Keefe, who you might think, oh, he's got a definite stake in this. Nope, not a party, doesn't get to make filings normally. Allowing for the material from a non-party is an unusual thing. And this is a good question. Is the judge a non-party? The judge is not just a non-party. The judge is like an active, the judge is even more restricted than the average non-party, if that makes any sense. Katie Cotton, I blame you, Ian, for my peanut butter and pretzel snack I had to make. Fair. I will accept that blame. The other thing is if you were asking me about how to set things up for if EDB was having audio problems, I'm happy to help out. Just get somebody to reach out to me and I can provide all of that, how I wrangle things. My wrangling things has managed to avoid the audio problems that have plagued some of the other channels right now with the StreamYard changeover. So, yeah. All right. So we've got the juror Doe, who, as mentioned, is a non-party because even though they have an interest, they are just not they're not part of the thing. So they want juror Doe, an interested non-party, moves pursuant to Rules 6 and 10 of the trial court rules for an indefinite order, extension of the order of impoundment entered sua sponte by the court, impounding the list of jurors in this action. Impounding is meaning just they're not letting the list of jurors get released to the public. If that impoundment order ends, then theoretically I could pull that juror list and just have a look at it and be like, oh, and then I could just phone them and be like, hey, I got some questions. Can you answer these questions for me? And we're not going to do that. I will small myself a little bit. I think the jurors have a very good claim to not want their information released. So, yeah. In support of their motion, Juror Doe submits that the real and present risk of personal harm to the jurors and to the integrity of their service is ongoing, i.e., they're saying, I'm in danger. I'm in danger. And they say Juror Doe was a juror in this action and wishes to maintain their privacy. So they actually say, like, we are physically in danger. And you know what? I think they actually make for a good case of it. And further, I think that this kind of shows us how some people in reporting on this case and in commenting on this case have crossed the line. We're going to see some commentary about how people have crossed the line. So, therefore, there continues to be a risk of immediate and irreparable injury should the juror list be made public, and good cause exists for an indefinite extension of the order of impoundment. What's an irreparable injury? Well, a repairable injury is one that you can fix with money. So as an example, right now, there is construction going on in my neighborhood. And the construction company has been rolling trucks over my lawn. I'm not happy about that. I can tell you that. I've been having some words with them. We're going to have some discussions. But they have been driving construction vehicles like dump trucks and backhoes and so forth on my lawn, which is going to kill the lawn in the place that they've been driving across it. I am pissed off by that. It makes me angry. But you know what? At the end of the day, it's a repairable injury. Money can solve the problem. Like, I can get somebody to dig out that, section, plant new grass, all of that. It's fixable. Irreparable injuries are things you can't really fix with money. And one of the most classic examples of things you can't get fixed with money is somebody's going to shoot you in the head. There is no way that the court has a lot of things they can order, right? The court has a lot of things they can direct people to do, but they can't unshoot you in the face. They can't, the court cannot write a writ of coming back to life. That is not a thing that is in their power. What else might be an irreparable injury? Irreparable injury might be things to your reputation. It might be an irreparable injury to have, for instance, revenge porn released of you because you just can't get that off the internet. Might be an irreparable injury if somebody destroys the Mona Lisa because you can't make another Mona Lisa. Even if you're a really, really good artist and you make an exact copy of the Mona Lisa, it's not the Mona Lisa because there's only ever one of them. You can't re-Mona Lisa. So all of these things are examples of potential irreparable injuries. And in this case, what they're worried about is the shot in the face thing, right? We might get shot in the face. So, and good cause exists for an indefinite extension of the order of impoundment. Basically, they want this to continue until further notice. So, yeah. In further support of their motion, Juror Doe relies on their affidavit and memorandum of law filed herewith. Also filed herewith are a proposed findings and order and an affidavit of service reflecting compliance with Rule 4 of the Uniform Rules on Impoundment. We are not going to go over the affidavit of service, by the way. That's just not going to happen. So, wherefore, Juror Doe, an interested non-party, respectfully requests that the court grant their motion and enter the following relief. 1. Permit Juror Doe to proceed using a pseudonym for the purposes of this motion. I think the court is going to grant that, and in fact, they have. 2. Find that good cause exists for an extension of the order of impoundment of the jury list, and extend the order of impoundment indefinitely, but no earlier than July 16, 2025. The court ends up granting it as indefinitely. But we now have a memorandum in support. Memorandum in support. Do we want the memorandum? Chat, do we want the memorandum first or the affidavit first? Which do you want to see first, the affidavit or the memorandum? The affidavit provides sort of some of the factual things. Just waiting to see what chat wants. If chat's got an opinion, I see somebody says yes. That's a very helpful, a very helpful thing. I see some people saying affidavit, some people saying memorandum. People are about split. You know what? Let's do the affidavit first. We'll jump in on the affidavit and then we'll do the memo. Affidavit of Juror Doe. Now comes Juror Doe, a pseudonym. Well, no kidding. Nobody thought that there was somebody who was actually named Juror Doe. But yes, this is a pseudonym. Who on oath deposes and says as follows. 1. I am of legal age and have personal knowledge of the facts set forth herein. That's just basically box ticking for the affidavit. You put that in. 2. I was a member of the jury that was seated in the recently concluded trial in the above captioned case. Okay, and you might say, how do we know this person is actually a juror? Well, the lawyer filing this, because there was a lawyer who filed this, the lawyer filing this has an obligation not to file false affidavits. And so because there's that obligation not to file false affidavits, hopefully that lawyer would have checked, right? 3, I just retained counsel to represent me. I've got a lawyer. 4, I have read the impoundment order entered by the Superior Court Associate Justice Beverly J. Canone on July 8th, 2024, which found that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. Why would they read it? Well, because I'm sure the lawyer said, you need to read this, right? As I read the court's order, it is scheduled to expire on July 18th unless it is extended by the court. You know what day it is today? It is July 18th. All of this was done just a couple of days ago. So, yeah. And Linux guy, you're not correct here. This is all because of Aidan Kearney and the antics he and his cult pulled leading up to the trial. They don't actually just rely on Turtle Boy. Turtle Boy's mentioned. Turtle Boy is mentioned, but Turtle Boy isn't the only thing that's mentioned. And some of the anti-Karen Reed side get shouts out here. So let's have a look at that. So I submit this affidavit in support of my request to extend the impoundment order entered on July 8th, i.e., there is more stuff here. So next, I am asking that the impoundment order be extended indefinitely because I am in fear of my personal safety and the personal safety of my family if the names of the jury are made public. Now, the thing is we want people to be on juries, right? We believe in the jury system. We believe that the jury system matters, both in Canada and the US. And so jurors need to be protected. Jurors need to know that the price of being a juror doesn't involve violence or reprisals or anything like that, especially because we very much want jurors to be confident. You know, we want jurors to rule based on the facts and not based on fear of what the public will do to them. You know, I've still got a hiccup. We want juries to rule fairly and not just out of I am scared, that I'm terrified of what people will do to me. So, yeah. I have read the impoundment order and noted on the very first page that individuals associated with this case have been charged criminally with intimidation. I am frightened for my personal safety as a result of learning that someone associated with this case has been criminally charged with intimidation. Now, who is it that was charged with intimidation? That's Turtle Boy. Now, I note he's been charged with intimidation. That doesn't mean he's been convicted of intimidation. He's just been charged with it. And the other thing is, I don't know if the jury, like if this juror would still have the same view about this charge of intimidation if they knew the background. Like if they knew what the charge was about, would they still be that worried? Because Turtle Boy isn't charged with like showing up at somebody's house with, with like one of these things to like threaten them, right? It's not that he showed up at someone's house and is like, I am gonna hurt you, right? That's not it. Turtle Boy is basically charged with allegations suggesting that he was, how do I put it? Excessively annoying would be a way to put it. Excessively annoying. So, I mean, if convicted, that's a bad thing, but it's not quite like he's showing up at anybody's door with a shotgun. I'm going to say if Turtle Boy was pissed off at me and wanted revenge against me, I'd be worried, but I wouldn't be worried that he was going to like kill me or kill my dog or anything like that. I'd be worried that he might make stories about me that might be embarrassing. I expect that they'd be true, but I suspect he would just be, what is that apparatus? This is a Macahuatl. I'm probably mispronouncing it. It is an old style war club made with shards of obsidian. And basically, these things are super sharp volcanic glass. And the way this was used is that you basically beat things with it while cutting them to. It's a nasty implement. So it is one of the coolest weapons that's ever been invented. I want to get a shark tooth sword as well, but those are hard to find. So yeah. It's kind of an Aztec weapon. So yeah, I don't think he's going to show up with one of those things. So next thing, they also note, I also recall testimony from at least one witness who described being harassed by individuals and her family being harassed because of their involvement in that case. You remember that, you remember that issue, right? You remember that, you remember that testimony from, I think that was Jen McCabe that testified to that. So, yeah. I do not know any of the specifics of any such harassment, because of course he didn't, because he's a juror. But I fear that my family and I will not only be harassed if the names of the jurors are made public, but that our personal safety will be seriously compromised. Okay, so there's some concerns there. So next thing is, during jury deliberations, we could hear protesters outside screaming and yelling. Okay, that's something that might cause you concern, right? You don't know what side they're on, but there's a whole angry mob outside. That's worrying. That's concerning. During our jury service, the members of the jury would meet at what was supposed to be a secret location to be transported to and from the courthouse by bus. After being discharged from jury service on July 11th, 2024, we were taken by bus back to what was supposed to have been a secret location, where we observed what appeared to be members of the media, including photographers. I was so much in fear on my way home that I pulled over to the side of the road to see if I was being followed. Thankfully, I was not being followed, but that was and remains my mindset. If juror names are made public, we will be constantly threatened and harassed, and there will likely be a physical confrontation at some point. He's like, why was the media there? Why did the media come and track us down? And that sounds like the media behaving badly. Lots of people comment and they're like, oh, these YouTubers, they don't have any code of professional conduct. Well, you know what? I'm not following the jurors back to their, secret places. So, yeah. Since being discharged from jury service on July 1st, 2024, I have read multiple news articles about the case and the attention that this case garnered across Massachusetts, New England, and the country. Also internationally, because I am international. Lots of you guys are international. Lots of you folks are, all sorts of places. So there are clearly people who have very strong opinions about the case and about the jurors who deliberated over many days. I do have a very, very strong opinion about the jurors who deliberated over many days. You ready for a hot take? Here's the hot take. My strong opinion about these jurors is that they did a heroic bit of public service. And like, absolutely, it is, what they did, they're should be commended and nobody should harass them. So yeah, I guess that's my strong opinion about the jurors is the jurors did their job and they did the job well, and nobody should be giving them any shit at all, ever. So yeah. I have seen articles, comments to articles, and postings about the verdict saying some very nasty and dangerous things. Hopefully that's not me. Like, hopefully that's not, hopefully I'm not included in that. Some individuals have expressed outrage and anger that the jury did not acquit the defendant. Some individuals have expressed outrage and anger that the jury did not find the defendant guilty. This is one thing that I find really interesting about this affidavit, is that this affidavit is very carefully written to be a both sides kind of affidavit. This juror doesn't want to give away where they were leaning. They don't want to give away whether they were going to convict or acquit. They don't want to give away what their feelings are. And so they criticize both people, right? They criticize both the pro-Karen people and the anti-Karen people, especially the more extreme people on those things. Just yesterday, I read an article in the Boston Globe with the headline, "Karen Read case ended in a mistrial, but the diehards haven't given up." In approximately the 12th paragraph of this article, an administrator of a Karen Read-focused Facebook group was quoted as saying, "The people who were on the fringe of being interested in it are now engulfed. The anger level was at a 9 before, and now it's at an 11.5. The article characterized this increase as a rising rage." Okay, is that out of 10? Is it 11.5 out of 10? But here's the thing. This is one person on a Facebook group. So, yeah. Later in this July 15th Boston Globe article, another individual interviewed by the reporters stated, "People are insane about this case. If they don't agree with you, they'll try to dox you. I understand the term dox to mean that individuals will publicize someone's personal information, including someone's residential address, occupation, business address, etc. Publicizing my personal information in this context exposes me and my family to unwanted and likely surprise encounters with strangers who likely have an axe to grind with any juror." Now, I'm just going to note as well, I had to make a decision when I started this channel. And the decision I had to make was, do I make my name and my details public? Do I, do I broadcast who I am? Because I could go under a pseudonym. It wouldn't have been Runkle of the Bailey if I was going under a pseudonym. It would have been, but you've got plenty of YouTubers who do so under a, pseudonym. I could have been something like, Maple Law or something. I don't know. That would have been dumb as a name, but I could have. And the problem with all of that is that, we've got Valhalla Awaits. Valhalla Awaits is under a pseudonym, right? The problem is that eventually somebody would have revealed who I am. And somebody would, like, a client would have been like, I know who this guy is. And so I was like, screw it. I'm just going to put my name out there. And not only do I put my name out there, I put my name out there in like just about every of one of my video on demand things. It's a choice. I will say I have had some people threaten to dox me, which is the funniest thing ever. I had somebody who sent me a thing saying that he figured out who I am and that he figured out that my real name is Ian Runkle and that he would reveal this unless I did a bunch of things for him, which included money. And I was like, yeah, here's the thing. You can't threaten to dox me because my name is in every video. It is like the channel name is Runkle of the Bailey. It's not freaking hard. Like, this is not difficult. So yeah, I was really impressed with that guy's like research skills, where he was able to figure out my name that is like in the first 7 seconds of every single video I make. So yeah. The other thing, I've got a current, like another guy who's threatening to blackmail me. But this guy is threatening to blackmail me with a publicly reported court case. It's my parents' divorce. He's like, hey, I will tell everyone this. And I'm like, cool, good for you. Go for it. Yeah. I kind of felt like the Batman. Everyone remember the Batman movie where the guy, is like, I figured out the secret identity of Batman. And Lucius there is like, well, so you think you found somebody who's, beats up who spends his spare time beating criminals to a pulp, and your plan is to blackmail this individual? It's like, I kind of felt like that. It was like, okay, cool. Not a great plan. All right. I agree that they should not be doxxed. So, yeah. I have seen social media posts that were very demeaning of and attacking the integrity of the trial judge. If someone is going to attack a sitting judge, I see no reason why they would not demean and attack verbally and physically a juror who sat on this jury. Now, here's the thing. Nobody has actually physically attacked the judge. Like, I don't think anybody has like tried to jump Judge Bev. Nobody's like come out and tried to like hit her with, with something like this or anything like that, right? So, I see there's a big difference between somebody online going, the judge sucks, which is absolutely constitutionally protected speech, versus like somebody going after her with a shotgun, right? There's a huge difference between somebody engaging in constitutionally protected criticism of a public official versus like chasing after that judge with a bat or something stupid like that. People absolutely should be able to criticize their public figures. I don't agree with all of the criticism, but I certainly agree that people should be able to make their criticisms, right? People should be able to do the like. So yeah. And yeah, I just don't see any. I don't see that this is a connection here. Like, listen, plenty of people will say that the president of the United States, or, I will say Justin Trudeau, I think he's an idiot. I think he's a moron. I think he's a terrible politician. But that doesn't actually, like, me saying that doesn't mean I'm going to attack him or something like that. I'm not like going to be waiting in an alley to like attack Trudeau or something just because I think he's just because I think he's an idiot. That's such a leap. I actually would not have put this into my affidavit. If I was the lawyer, I would have cut that line entirely. I would have been like, yeah, that's not going in there. So I understand that there are individuals who are upset that an impoundment order was entered and that they're actively seeking the identity of all of the jurors. That, I think, is true. For example, my attorneys have made me aware of a video posted by a blogger/journalist whom I understand to be a person who has been charged with witness intimidation related to this case, speaking about the trial and the jury's inability to reach a unanimous verdict on all counts after trial. In the video, the blogger initially states that he has identified the jury foreperson in the case. Not only does the blogger state that he's identified the jury foreperson, but also where this person lives and what the person does for a living. A link to this video can be found here, and they provide a link to Julie Carr 94. I looked at Julie Carr 94. She apparently blocked me for some reason. Okay. So in this same video, the blogger demands to know the identity of the expletive idiot on this jury who did not vote in his preferred manner, and further that whoever did that subverted justice, like they helped cover up for a murder. As far as I'm concerned, fuck them. That's what I think. Now, again, this appears to be Turtle Boy. This blogger/journalist that they're talking about is probably Turtle Boy. Yeah, somebody says it's Julie Carpenter. I vaguely remember her. I seem to remember encountering that, I seem to remember coming to the conclusion that Julie Carpenter was an absolute loony in a way that feels kind of offensive to like actual people with like genuine mental illness who don't have any, who don't need to be compared to her. So, yeah. Is the juror's attorney made them aware of the video? Why is an attorney stoking the juror's fear? The attorney is helping the juror. He's helping, or the attorney's helping the juror with their application, right? He's helping support that. So now here's the thing. States that he's identified the jury foreperson. Does he actually, like, what we don't see here? What we don't see here is that she didn't actually, what is it? Like, did Turtle Boy actually dox the client or dox this, this juror? Because it doesn't say that he actually revealed any of that information. It just says that he identified it. Did you at least workshop channel names before settling? Names like the armed attorney or attorney at arms, the shotgun solicitor, bore-sighted barrister. All of those are better names than what I settled on. I will tell you, I did not workshop anything. I just had the idea, like, Runkle of the Bailey came to me when I was, just sitting around. So, yeah, I think it came to me while I was doing like yard work. Yeah, Turtle Boy said that he could identify the juror by name, but chose not to. They're leaving that out because, yeah. Like the guy who tried to make Nate the lawyer look bad because he had naughty parents. Nate comes back with, yeah, so I became a cop and then a lawyer despite growing up in poverty with drug-addicted parents. Yeah, Nate totally dunked on that. All right. In the same video, the blogger demands to know the identity of, or we just covered that. The blogger states in another video posted to X, who outed the Chesna juror. Remember that? The one woman who hung the Michael Chesna trial in July. The jury lists are public, So I got the jury list, and I went down the list, and I found the juror who hung the jury, and I shamed her, as I should, because it's shameful. Turtle Boy needs to shut up. I don't mean generally. I just mean that Turtle Boy sometimes seems to be causing some trouble here. And the thing is yes, these are all out of context. And yes, this is sort of an issue there and whatever else. But that's always gonna be the case when you're dealing with an affidavit, right? So the thing is you don't want to get too close to the case, because when you become too close to the case, you end up in filings in the court case, and that's the problem. So, like, yeah. That said, Turtle Boy also did some really good research on this. So, he gets to, he makes his own call. Just, he ended up in the filings, right? And that's not ideal to end up in the filing. So, potentially criminal has some opinions about Turtle Boy. They're probably too spicy for here. I'm curious because I've never actually seen it. So I've never seen his take on that. So yeah, I mean, Turtle Boy is actively at this point causing some problems. Now, the other thing I'm just going to note here, I am just going to note some issues on this. Some things that just stuck out at me. So we have the details there, a link to this video. Now, I would have gone and found the link to the video on Turtle Boy's webpage, right? But instead, where are they finding the link to the video? They're finding the link to the video on Julie Carpenter's Twitter page. The other thing is we find a link to the video on Heels in the Air. Heels in the Air is also, I wasn't aware of who they were until I looked them up as a result of this filing. They're another very, very strong anti-Karen Reed account. So what I'm seeing is that this guy seems to be doing his research on the anti-Karen Reed side of the internet. So, yeah. I understand that the above-mentioned blogger has been accused of harassing witnesses to the case, including by organized... Oh, Heels in the Air passed away a few months ago. Did not know that either. I am sorry about that. It's kind of a cool name. Kind of an evocative name. We'll go with that. So, I understand that the above-mentioned blogger has been accused of harassing witnesses to the case, including by organizing crowds of people to harass them outside of their homes, and I'm aware that he's made statements in a blog from 2023 to the effect of, murderers and those who cover for them do not deserve to live a comfortable life while Karen Reed suffers and fights for justice for John O'Keefe. If, as he has stated, this blogger believes that members of the jury on which I served helped cover up for a murder, and he further believes that those who cover for murderers are legitimate targets of harassment, I fully expect that members of the jury will be subjected to efforts to harass and shame them, with the very real probability that some physical confrontation will inevitably occur. So there's a lot of, I am afraid of Turtle Boy here. My concerns are not limited to a particular blogger or to a particular side of this case. You did spend a lot of time looking at one particular blogger, and your evidence all seems to be to one particular side of the case. I am aware that there are other outspoken bloggers, commentators, and groups of people who wished for a guilty verdict on some or all charges against the defendant. I am aware that there have been physical confrontations between the two sides of supporters. don't get into a fight on this, right? Don't anything, like, come on. So, an example of this is from 2 recent postings by an individual who appears to be a reporter from New Bedford. In today's post, she stated that she was in court today defending against a harassment charge against her and her pursuit of a counter harassment charge. Yesterday, this reporter posted about getting protection from another blogger. While I do not know the facts concerning these court appearances, it is very evident that individuals on all sides in this case have acted irrationally and aggressively over the past few years, which has caused multiple court appearances by parties seeking protection of the courts from other individuals. In light of the mistrial, there is no end in sight to this irrational behavior, which clearly continues today. Jurors will undoubtedly be subjected to harassment and likely physical confrontations if their names are made public. My affidavit in motion should not be interpreted as indicating how I or any other juror voted in this case, or how I or any other juror feel about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large portion of the public who intensely followed this case. And you know what? I think that this is correct. I think that, like, I don't think anyone's gonna go and punch a juror, or I don't think anyone is going to go and attack a juror or anything like that. I just don't see that, right? But I do think that it's likely that somebody will show up to one of the, at one of the juries, one of the people's, houses or whatever, their place of work. I'm going to try to avoid getting too political, but I suspect that everyone saw the Home Depot woman who said something stupid on Facebook, as people do on Facebook. So they said something dumb, and then somebody came to the Home Depot where they were working to confront them about the dumb thing they said online. And then they, then they went and said, oh, well, and Home Depot fired that person. I could absolutely see somebody would be sitting there working, their day job, and somebody comes in to be like, so what are you gonna, you wanted to acquit Karen Reed, like F you, or you wanted to convict Karen Reed, F you. I don't have Facebook. What happened? Somebody posted a dumb thing. They basically hoped that they basically said that they hoped that the person who shot at Trump would have had better aim. It's a stupid comment. It's the kind of stupid jerk things people say on their Facebook all the time. I don't care where you are politically, but it's still a stupid comment. Like, regardless of what side you're on, it's not a great comment. But somebody showed up at her work to harass her about it, and then she got fired. And I'm like, okay, I guess, like, people would have, like, jurors might have a reasonable concern that somebody's going to show up at their workplace and get them fired. Because there's plenty of jobs that might fire you just because you've got people who are coming in hassling you, right? Like, let's say, let's say you work in a restaurant, right? And let's say you say something that is entirely innocuous that people misunderstand, right? You go and you say something like, let's say it's like something that's completely misunderstood. Like you say, I hate the red ones, referring to like candy. And somebody takes that as like, a comment about people, like a racist comment. And so there's an angry mob just because you had a particular take on which kind of gummy bears were the tastiest. So, but then here's the thing. The internet runs wild with this comment. They've misunderstood it. Nobody bothers to get the context. And you work as a waiter. And then suddenly the restaurant is getting packed with protesters. The restaurant's going to fire you, even though they realize that it's unfair, because they just can't have their restaurant packed with protesters, right? So that is, I think, a fair concern. Fair concern. All right. So he wishes to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during our deliberations. It also sounds like the jurors were fairly. It sounds like the jurors kind of have some concern for each other. So it was an honor to serve on the jury. It was also a significant sacrifice of time, which I understood and anticipated when I was selected. It sucks to be a juror, right? What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. Don't do that, right? Don't harass the jurors. And I see people saying someone in the McAlbert's camp has tried to get people fired. Yeah. If jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer to not have to respond to these inquiries. However, what I fear is not only will I be subject to requests for interviews. Now, I'm just going to say, I would not say that it is sufficient to. I would not say that it is sufficient to justify this order if the issue was I don't want reporters to contact me. But the concerns about will people harass us is a different story. So, and somebody says nobody is contacting the jurors yet. They might. So, but that I will be targeted and harassed because of what I did or did not do on that jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I am not prepared or equipped to anticipate and prepare for any surprise personal attack. Mystery juror, if you reach out to me, I will anonymously, without telling anybody, I have resources in the firearm community to arrange for you to get some training. Assuming you're not disqualified from having a firearm, which I don't think is the case, I would make arrangements to get you some training and some, ability to defend yourself, because nobody should be attacking you. But if somebody does, I wish them a very merry concealed carry permit. So, yeah. More importantly, I feel that I will not be able to protect myself and my family. Fair. Now, somebody says, is this the foreperson? It's well written, like the note was when they told the judge they were at an impasse. Here's the thing. The affidavit is almost certainly mostly drafted by the lawyer, right? The lawyer is going to do the writing and then is going to get the client to review it and agree that that's their affidavit and so forth. So, yeah. So I don't think that we can infer anything from the writing style. I think this was written by the lawyer. That's it. So I'm not inferring anything from the writing style at all. The person could literally, this juror could literally be a halfwit, right? This juror could literally have the IQ of a warm cup of coffee, and they could still get an affidavit out like this because there's going to be a lot of lawyer involvement in the drafting. So, yeah. All right, we're going to go through some super chats, and then we'll go through the memorandum in support, which is a little longer. It is 10 pages. So let's go through some super chats here. DSN, thank you for the gifted membership. Much appreciated. Pampered Shelley, served on a jury this week. State didn't bring the evidence to convict. Thank you for serving on the jury. And thank you as well for, evidently, if you're sitting there saying that the jury didn't bring the evidence to, or the state didn't bring the evidence to convict, it means that you thought about it. It means that you considered the evidence and went, it's not there yet, and the standard is high because it's proof beyond a reasonable doubt. I am okay with convictions. I'm okay with acquittals. I'm okay with, hung juries. I just really like juries that that are thoughtful, that consider all of this and so forth. So, yeah, I am very much a fan of that. If every juror took the time to think about it, and it's important, right? So, yeah. All right. Sarah Smiles, hi from Rhode Island, US. I'm new to your channel and chat. I really enjoy listening to you and hearing your perspective. I'm interested to learn more about Canadian law as you cover different cases. I want to figure out how to cover more Canadian cases. They're just hard to do because we don't really have video. Debbie W., count 2 is the one with the chain of events letter included. If jurors felt that her dropping him off at Brian Albert's house set the chain of events in motion, then I could see how they could vote guilty on it. Yeah, but that would be a mistake for the jury. That would not be proper. Jen Decimio, thank you so much for the membership. Much appreciated. Joe Loy, what is your bank account and sort code? As it turns out, because I'm an elf, I am so old that my bank account number and sort code are both 1. They're both just 1. I've got the first bank account and the first sort code. So head into the bank and try to take out my money and just be like, yeah, I need the account 1. So you need to take Turtle Boy's trial more seriously. I'm going to do some looking into it, but yeah, we'll have to. That's for later down the road. Danielle Cole, thank you so much for the super sticker. Much appreciated. Laura Riker, does this cry that the DA and Bev help word this? I don't think so. I don't think either of them would have any involvement in this. There is the possibility, of something like the jury, like that somebody like the McAlberts or somebody else, that somebody else reached out to them and encouraged them to make this request. That is possible, but it's not likely. I do not think that Lally would have had any involvement in this. I don't think that would have had any sort of issue there. Bev, I do not like. As much as you might have criticisms of Bev, as much as you might have criticisms there, I don't think that she would no, I don't. I just don't see it. Have you seen your unsub friends are being made into D&D characters by Tactical Turtleneck? I did not know that. I've actually never watched the Unsub podcast. I'm aware that it exists. I haven't watched it. Maybe I should. So, H. Scorpio, this helpfully confirms all my prior opinions. Love that. Jackie Lindy, John Ronson wrote a book on the cancer that public shaming is. So you've been publicly shamed. People have been fired because of public shaming. Yeah, I kind of want to read that one. The prototypical case is a woman who made an absolutely so this woman made an absolutely idiotic, ignorant comment before she got on a plane. She basically gets on a plane, and before she gets on the plane, I think the comment she made was something like, "I'm going to Africa. I hope I don't get AIDS, lol," or something like that. Anyway, that exploded all over Twitter, all over everything. And by the time the plane landed, her entire life was over. She was fired. Everything about her was published online. People just completely ruined her. Something about Ebola. Oh, no, she says, "I won't get AIDS. I'm white." Okay, fair enough. So, yeah, her entire life. And the thing is, it was an obnoxious comment. It was a stupid, reprehensible, gross comment. But the problem is that the internet doesn't really know how to do nuance. The internet doesn't really know how to do, and the thing is like every single person on the internet is taking what they think is a reasonable step. Like they are voicing their disapproval. And the problem is that all of these voices end up being this huge giant laser that destroys people at the end of the day, when it's just like, oh, that's kind of a dumbass thing. Maybe it shouldn't be the end of your life. And yeah, it's yeah, in fairness, this is not a new thing. Boycotts are named after a person. The ironic thing is that the guy who was boycotted actually there was better grounds for it, because that guy was a politician, and I have a lot less sympathy for a politician than just some random person online. So, Tough Cookie, thank you for the 10 gifted memberships. And Dragon Star, thank you for 10 gifted memberships. Joanne Heidenberger, are you going to cover the witchcraft trial in Iowa? They're on day 3 tomorrow. I am going to have to try to catch up on this. I don't know anything about what it's about yet. People have been asking me to cover it. I'm going to have to try to catch up. I might end up doing recaps. So, yep. Githralkin, context is difficult to textualize. Yep. Absolutely is. Okay. Let's have a look here at... yeah, nothing is ever as funny as when you try to explain it. Yeah, it's true. So, all right. Let's have a look at the memorandum. And we're going to have to embiggen the memorandum. We're going to have to embiggen it. Memorandum in support of emergency motion of interested non-party juror Doe to extend order of impoundment of jury list. All right. On July 8th, yeah, I see people talking about, James Charles. He's doing fine with his... he's got more money than I do, so he's doing fine. Yeah. So, noting that this case has received significant and divisive attention in Massachusetts and across the nation, issued an order of impoundment after finding that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. The court found good cause after concluding that there is a real and present risk of personal harm to the jurors and to the integrity of their service. So, see the order. Interested non-party juror Doe served on the jury and wishes to maintain their privacy. Because of the risk of harm to the members of the jury, including juror Doe, is ongoing and unlikely to abate in the foreseeable future, juror Doe has moved pursuant to the rules of trial court for an indefinite extension of the order of impoundment. Here's the thing. The interest in this trial will abound or will abate at some point. It will at some point end. But the problem is it's going to be going for a while because they're looking to retry Karen Reed, right? They're going to retry this. And so there is ongoing issues on this one. And, but the thing is at some point, the Karen Reed trial is going to end. She's either going to be convicted or she's going to be acquitted. And one thing or the other will happen. And like a couple of years after that, people might talk about it. Like people might mention this. But it's not going to be as, nobody's going to be as angry forever, right? Nobody's going to be as angry for, like in 20 years, they're going to find something else to be pissed off about. So that's kind of the thing, right? That said, I see it's going to be tough to seat a jury for a retrial. It's going to be even tougher to seat a jury for a retrial if you've got people who have been, if the last jury, if things went crappy for that last jury, then it's going to be even harder to seat, seat people for a mistrial, right? How do you get people to sit on the jury? And yeah, here's the thing. Lots of us are still like interested in Depp, but not as interested. Not as interested in Depp. So yeah. All right. Brief procedural history relevant to this motion. On June 9th, 2022, the Commonwealth returned an indictment against the defendant, Karen Reed, charging Ms. Reed with second-degree murder on docket number 1. So, on March 26, 2024, the Commonwealth moved to establish a buffer zone surrounding Norfolk County or Superior Court during the trial of this action. The court allowed the motion after noting that it is well documented that protesters have shouted at witnesses and confronted family members of the victim, and that witness intimidation has also been a prevalent issue in this case. A single justice upheld the buffer zone order, noting that demonstrations near the courthouse could expose witnesses and jurors to intimidation and harassment, undermining their ability to testify or to serve without fear of reprisal. Now, I'm just going to say the Depp trial, the Depp proceedings were a lot more civil than this. Nobody was harassing witnesses at the Depp trial. Nobody was like, I saw some of the Amber Heard people saying that there were signs saying things like death to Amber. I can tell you, I saw those crowds. There was no death to Amber signs. All of the signs were just support for Johnny Depp, or there were some signs of support for Amber Heard. There were, but there was a generally friendly environment. There was a guy bringing out with alpacas. There was like a guy who was a Depp impersonator who was wandering and sort of working the crowd and getting some tips off of that. There was people sending pizza to the line. Thank you, by the way, to the people who did that. So there wasn't, and nobody was really protesting. Everybody was just there. Lots of people were just there to see Johnny Depp, right? Lots of people just wanted to get a glimpse of Johnny Depp. Ian had pizza. Yeah. Don't boop the middle alpaca. That isn't an alpaca. That is a runkle. Fair. All right. Trial was held over several weeks between April and July. The case went to the jury, but after several days, the jury was unable to render a unanimous verdict on all 3 counts of the indictment. On July 1st, the court declared a mistrial. Defendant moved to dismiss 2 of the counts of the indictment after the trial. Ms. Reed supported her motion with declarations from her attorneys recounting statements from jurors regarding the jury deliberation and interactions between jurors following the declaration of a mistrial. The circumstances of the trial and post-trial motion practice have further intensified emotions about the jury and its individual members. On July 8th, the court issued an order of impoundment impounding the list of juror names and addresses. Among other reasons for entering the order, the court remarked that people associated with the case have been charged with intimidation. And so it notes that the order of impoundment will expire today unless otherwise ordered by the court. And that sentence had too many capital letters. Apologize. So, good cause exists to extend the impoundment order. So, applicable legal standards. I don't know if that sound played. My sound bar has not been functioning super well. The order of impoundment is issued pursuant to Rule 3 of the Uniform Rules of Impoundment Procedure, which authorizes the court to impound materials on an ex parte and/or sua sponte basis. Ex parte means that one side can apply. And what is ex parte used for? Ex parte is typically used for situations where you have to do something in a hurry. So one of the classic examples of an ex parte situation is an emergency restraining order, right? So let's imagine, lawful law. So let's imagine you've got a circumstance where, your partner has threatened to kill you, and maybe they came over to your house and like broke your nose and knocked out 3 of your teeth, and you're worried they're going to do it again, right? So you go to the court and you're like, I need an emergency, restraining order. I need an emergency order. And the court's not going to be like, well, you have to do this with notice, and you have to do this with, there's got to be time for them to get there. They're going to say, we're going to allow this to be done ex parte on an emergency basis, and then we'll, decide that later. So that's ex parte. Just one side is there, the other side is not. Sua sponte is that the judge is doing it on their own motion. Canadian courts don't typically use sua sponte because Canadian courts have been moving away from using Latin because Latin sucks and we should not use it. Acceptable uses for Latin are like you need to make a video game character sound cool, or you need to like name a new species of beetle. But I don't think Latin should be used much in the courts. I'm not a big fan of it because the courts are supposed to be accessible. They're supposed to be understandable to the ordinary person. They should not be... Latin in the courts tends to make it more arcane and, and difficult for the ordinary person to understand. So I don't like Latin. I like that the Canadian courts typically say the court did this on its own motion. Side rant. Side rant on that. So, yeah. All right. The committee notes to Rule 3 reflect that a court has the inherent power to impound its files in a case and to deny public inspection of them, and that is often done when justice so requires. So, sua sponte impoundment orders expire 10 days from the order of issuance unless otherwise ordered by the court. Why do sua sponte things? Well, because it's the court saying, I want to, I want to prevent something bad from happening. They give 10 days, and that 10 days is long enough to figure out, the 10 days is long enough for any people who have a position to get their case together and sort it out. So that's why it's 10 days. An impoundment, so the rules authorize a party or interested non-party to file a motion to modify any such order. An impoundment order may be extended only after hearing and upon good cause shown. In determining good cause, the court shall consider all relevant factors, including but not limited to 1, the nature of the parties and the controversy, 2, the type of information and the privacy interests involved, 3, the extent of community interest, 4, constitutional rights, and 5, the reason for the request. Okay, we're going to see how they're going to do this. So court records may be impounded if the court finds a risk of personal harm or harm to the integrity of the judicial process. So Juror Doe acknowledges that a jury list, if such a document exists, so they're noting that they assume the existence of a list. Okay. They're saying we don't know if a list exists, but if a list exists, then okay. So Juror Doe further acknowledges that court records are presumptively public. However, this principle is not absolute. Court possesses supervisory power over the records and files, and if properly denied public access where those records and files might have become a vehicle for improper purposes. So impoundment is available upon a showing of good cause. Withholding the names of trial jurors from press or public after the trial is terminated involves a clash of constitutionally protected interests, i.e., this juror has a constitutionally protected right to participate in a jury trial. But other people have, arguments aren't accessible to the average person, so let's be rid of those too. The Latin makes it more so. More so. I'm just not a fan of the Latin. So withholding the names of trial jurors from press or public after the trial is terminated involves a clash of interests. These interests may include the press's First Amendment right of access to criminal trials, the defendant's Sixth Amendment right to a fair trial, and the jurors' interest in having their privacy protected. So in considering a motion to impound judicial records, the court may take into consideration the privacy interests of third parties. In dissent in Fujita, Justice Gantz cautioned that the risks of disclosing a juror's identity may extend to the judicial process itself. His dissent is worth quoting at length. Now, here's the thing. Whenever you're quoting a dissent, you are quoting the losing side. You are quoting the losers, right? This is not the winning side. This is not what the court found. And so you're saying this is persuasive language that also is not the law. So it's always an interesting move. I avoid quoting from dissents because, quite frankly, quoting from dissents, usually when you quote from dissents, what you're acknowledging is that the law is not on your side. And I don't like doing that in my filings. I like to say the law is totally with me, and the other side are the people who don't understand that. So, yeah. Yeah, Githralkin says, don't quote the losers. That's pretty much it. It's like the losers are on my side. The losing, law is with me. It's like, oh, well, that sounds like you're also a loser. We'll just put you in that same category. So, yeah. All right. I also fear that the creation of a juror list to be included in this case, file, may over time diminish the fairness and impartiality of jurors. Jurors are the only persons in this country that we presently draft into government service. We ask them for a few days or a few weeks to put aside their employment, educational or family responsibilities, and devote their full attention to a criminal or civil trial where they will decide guilt or liability. We have had few instances in this Commonwealth where jurors have been threatened or harassed after their verdict, but many jurors fear the possibility, especially where they reside in or near the communities of the litigants or the litigants' families. By making it easy for anyone to obtain their names, the risk of such misconduct will increase, and jurors fear that their verdict may make them the target of such misconduct, even if it is only an angry telephone call or Facebook posting, will increase proportionately. Now, I just want to note, let's consider the sort of the worst case hypothetical, right? Let's consider the absolute worst case hypothetical. So let us imagine that everybody in a case thinks that, like, Joe Boggs committed a murder. And let's say they imagine this because a whole lot of details were revealed that suggest that Joe Boggs committed the murder, right? And so publicly it was released that, like, just before the murder, Joe Boggs was seen in the area of the crime. And in fact, he was seen in the area of the crime carrying a machete. Or hell, let's make it really unusual. Joe Boggs was seen in the area of the crime carrying a Macahuetl, right? A very distinctive weapon. And then it turns out that somebody is murdered with, like, a Macahuetl, right? It's a really distinctive weapon. And so the public is absolutely convinced that it must be Joe Boggs that's committed this crime, that Joe is absolutely guilty, and they will not accept any other verdict, right? They won't accept any other verdict. But then the trial happens, right? Then the trial occurs, and the jury is sitting there. And outside, there are protesters. They are calling for the execution of Joe. Joe must be sentenced to death. Joe must... all of these things, right? And the jury is sitting there, and they hear from Joe. Joe says, yeah, I had the Macahuetl. I was taking it there because somebody online on Facebook Marketplace was going to buy it. And I was going to deliver it to this dude. He's deleted his account right afterwards, but I was delivering it to this dude. And, then the dude hit me with a brick and took the thing. And I don't know what happened after that, but, and so they call a police witness who says, yes, actually that contact did happen via Facebook. And then they managed to arrest the dude. And the guy is brought into court and says, I absolutely lured this guy there to steal his weapon and then murdered somebody with it. So now the jury is sitting there facing this trial where they're asked to convict Joe, and it is very clear that Joe didn't do it. But the protesters outside will not accept any other verdict other than Joe did it. Joe must be convicted. Do we really want those jurors to convict Joe knowing that he's innocent just because they're worried that they're going to get attacked when on the way out? Is that something we want? It is important for the process that the jurors be able to make their decision without fear from the public and without having to worry about whether the public is going to harm them afterwards. So that's the issue of the functioning of the jury system. So the court determined that a judicial finding of good cause may include a risk of harm to the jurors or to the integrity of their service. Similarly, the Fifth Circuit indicated that a risk to the personal safety of jurors obviously would constitute good cause. Let's say the guy who is on trial is a mafia kingpin, right? You've got a juror, or is I don't know, he's like Putin's third cousin or something. And the jury legitimately has a concern that they are going to get murdered if they vote the wrong way. Then maybe you want to protect the jury so that they don't get murdered and so that their verdict isn't based on their concern about getting murdered. Right? So, yeah. Personal safety is obviously an appropriate thing. Were jurors to feel that their personal safety was at risk, they might not only be reluctant to serve, but might tailor verdicts so as to forestall harm to themselves, thus depriving the parties of an impartial jury. The First Circuit stated that it will defer to a trial court's factual findings on this issue, and that it would not lightly second-guess the district judge's essential role as trial administrator when he or she makes reasonable practical decisions, balancing some of the competing considerations discussed herein in light of the realities of the particular case. So they say, good cause exists to impound the jury list. Upon entering the sua sponte impoundment order, I'm getting a weird flicker from StreamYard. StreamYard, stop flickering. Stop the flickering. It's driving me nuts. So the court determined that there is a real and present risk of personal harm to the jurors and the integrity of their service. This determination was correct. And the impoundment order must be extended because these risks continue to exist and are likely to intensify. I don't think that they're saying that Turtle Boy specifically, well, I guess they are saying that Turtle Boy specifically is a threat. But, I mean, somebody else might be a threat. Like, somebody else might be, might be inclined to violence. Yeah. All right. So the public interest associated with this case is unique, not just for its intensity. I've actually found it to be far more intense than many of the other trials that I've covered, right? Lots of people have had opinions. There have been people who have beaked off about me, at me about Baldwin, but not in the same way that people have had opinions about Karen Read. Karen Read has gotten people with serious anger. So, yep. But for the extent to which segments of the public have become invested in the outcome and taken sides for and against persons affiliated with the case. I'm just going to say, at the end of this trial, I am Team Chloe. Justice for Chloe is where I sit. Indeed, both this court and the single justice of the Supreme Judicial Court recognized that in imposing a buffer zone around Norfolk Superior Court during the trial, the circumstances of this case continue to pose a unique risk of personal harm to the jurors. Juror Doe notes that in their affidavit, the jury recognized the intensity of the public interest during the trial. They heard protesters outside the courthouse yelling and screaming. After being discharged from service on July 1st, the jury was taken by bus back to what is supposed to have been a secret location, where they observed what appeared to be members of the media, including photographers. Juror Doe says that they were so much in fear on their way home from jury service that they pulled over to the side of the road to make sure they were not being followed. Now, Juror Doe is probably a little bit panicky, right? A little bit over concerned. But I'm going to allow it, right? I'm just going to allow that Juror Doe might be a little nervous, right? They're allowed to be they're allowed to be worried, right? So, yeah. What's this? They each side of the issue appears to include persons willing to inflict or to encourage others to inflict harm on persons associated with the case. As the court is aware, there have been many accusations of, and at least one arrest and charge for, witness intimidation. The blogger, who has been charged with witness intimidation, has characterized any jurors who did not vote to acquit the defendant as idiots who helped cover up a murder. He is, by the way, that is actually constitutionally protected speech. That is protected speech. This accusation is, of course, absurd. I mean, the helped cover up a murder part is absurd. The idiots thing is pure opinion. So can't really be opinion to think someone's an idiot, or absurd to think someone's an idiot. I think lots of people are idiots. I kind of think I'm an idiot sometimes. So Mrs. Runkle would probably agree. Mrs. Runkle would probably agree. So, yes. This accusation is, of course, absurd, but it is noteworthy because the blogger has demonstrated how he treats those whom he believes cover up murder. He has been accused of, and essentially admits to, harassing witnesses, and has made statement to the effects of murderers and those who cover for them do not deserve to live a comfortable life. The blogger has gleefully admitted, to obtaining a public jury list in a different criminal case and shaming the jury or the juror who did not deliberate in the manner he preferred. Somebody says that's imposter syndrome, Runkle. It is and it isn't, because I will tell you that I have previously... so recently, I went and bought fish because I was planning on eating fish. And then I went and very carefully set the fish in the cupboard, and I ended up putting like something else in the fridge. And it was not my brightest move, because I found out that I made this move when I discovered the smell of the fish. Yeah. So someone please tell me the name of the document Ian is reading. This is the memorandum in support of impounding the names of the jury. So, yeah. All right. Some among the defendant's detractors pose risks of harassment and violence as well. Juror Doe is aware of dueling requests for harassment orders and physical altercations between the two sides. Juror Doe Affidavit 23 and 24. As recently described in the Boston Globe, the people who were on the fringe of being interested in it are now engulfed. The anger level was at a 9 before, and now it's at an 11.5. As quoted by some random anonymous person who, okay, yeah. Fridge belongs in the fridge, dude. I know. I know. Yeah. Yeah. So the anger level, or the article characterized this increase as a rising rage. I actually think it's been diminishing lately. I think it's actually been diminishing. The article goes on to quote another interviewee as saying, "People are insane about this case. If they don't agree with you, they'll try to dox you." The jurors, if identified, are likely to become targets of harassment, abuse, doxing, and potentially violence. The nearly unprecedented and vitriolic public interest associated with this case is likely to put it squarely within the few instances in this Commonwealth where jurors have been threatened or harassed. The court would be well within its discretion to find a continuing risk of personal harm to the jurors, and that good cause exists to permit them to remain anonymous if they choose to do so. And there's a substantial risk of personal harm or to the judicial system. Now, this is a stupid phrasing. Personal harm to the judicial system? The judicial system isn't a person. The judicial system is not. The judicial system can't suffer a personal harm. It can only suffer general harm. So you can say there's a substantial risk of harm to the judicial system, but like personal harm is like somebody stabbed me in the kidneys. The judicial system does not have kidneys. You can't stab it in the kidneys. So, yeah. There also exists an ongoing risk of harm to the integrity of the judicial system. Again, as cautioned by Justice Gantz, the creation of a juror list to be included in the case file may, over time, diminish the fairness and impartiality of jurors. If jurors fear reprisal in the form of shaming, abuse, or harassment, it will make it more difficult both to impanel a jury and for individual jurors to remain fair and impartial. The risk is not abstract, particularly because our Commonwealth versus Reed is not over. In the event of a new trial, the parties will need to impanel a new jury. No doubt that will be a difficult task in any event. Yeah, I agree. That will. What is it? I once dated the judicial system. She's a nice person. Nice. Nice. So, no doubt that will be a difficult task in any event. But if jurors from the first trial are identified and harassed, it will be even more difficult to find jurors willing to serve and potentially be subjected to the same treatment. I mean, let's consider the worst case scenario. Let's consider that a juror comes out and says, you know what? I was definitely going to, and then insert acquit or convict here, right? I was definitely going to one thing or the other, right? I was definitely going to do a thing, right? And then that juror ends up getting murdered, and they find spray painted on the wall, either like FKR, or like, I don't know, does the other side have like a catchy 3-letter acronym? Do they have like jail Karen Reed or something? I don't know what their symbol is, how they rally behind. Or maybe they just put like F Karen Reed and it's not free, right? So at that point, if you're a juror for the new trial, do you really want to like sign up for that? Do you really want to be like, yeah, that other person is, that other person got murdered. I could totally get murdered too. That sounds like fun. Yeah. There's a real risk to the administration of justice and to the parties' rights to a fair trial. The court should minimize this risk by extending the order of impoundment. Now, I'm just going to say, not everyone is like me. Not everyone is like my particular style of things. Because when I get a death threat, I'm like, challenge accepted. Like, when I get a death threat, it's like, bet? Like, do you think that's how that's gonna go? Because yeah, I'm just kind of looking around and going, maybe not, right? Maybe this is not your moment. So, but not everyone is in the same position. And it's reasonable to be concerned. And the thing is I do have a little bit of worry when somebody threatens me, because I always have a little bit of concern that, like, they're going to meet Mrs. Runkle, and Mrs. Runkle will not be as, like, how do I put this? Mrs. Runkle would defend herself, but she would also take her time about it. The defense of herself might take like a couple of hours, and that would just create all sorts of legal issues that she doesn't need. So don't mess with Mrs. Runkle. She's scarier than I am, like, legitimately. So proceed under pseudonym. Finally, Juror Doe requests that they be permitted to proceed under a pseudonym for purposes of this motion. The same reasoning for the motion to extend the order of impoundment underpins this request. Juror Doe files this motion to protect his anonymity and that of all other members of the jury who wish to remain anonymous. Requiring them to proceed under their name would defeat the purpose of the motion and would threaten the very interest Juror Doe seeks to protect. So this, I think, is a fairly obvious, sort of, I think that feels like it's fairly obvious to me, that they, that if they're going to grant that they should also, allow this juror to be anonymous. So let me give some takes on this. First take, the juror here does seem a little bit panicky. They seem like the sort of person who I don't want around in a crunch. You ever have that person who, when things are going badly, is really good at making them go worse? That person where you're like, hey, you're sitting there and, Mrs. Runkle is not that person. We had a sewage flood at one point. We had a sewage flood in our basement. It sucked. We, at the sewage flood, Mrs. Runkle and I both were pretty good people for dealing with this. We were just like, oh, there is a sewage flood going on. Let us identify the things that are most at risk and most important to save and start saving those things. And, we were just like, we can't stop this. We don't have a way to, like, unflood this. Because, if poop is coming through the sewage lines in reverse, we don't have a way to stop that. So we were just like, okay, do what we can. So we were going, and like my family Bible got rescued. I'm not religious, but I still have a family Bible that I don't want to get ruined. My copy of The Lord of the Rings, that is a very nice copy, already has a little bit of water damage, but it doesn't need to be that water damaged. A bunch of those things. Like, we just, and like, I'm busy getting books, and Mrs. Runkle is like, the guns, get your guns out of, so I did all of that. So we got everything. Like, we didn't lose anything super precious to us, right? And that's because we were both able to respond to it and to deal with it. But you ever have that person who just like starts freaking out whenever something goes wrong? Like, you get a flat tire by the side of the road and they're like, oh my God, we're gonna die. And you're like, shut up, I'm trying to change the tire. Like, those people, I feel like this juror goes into that category. Like, where they're just going to be like, oh my God, that we're going to die. And you're like, it's a flat tire. I at one law firm I worked at, I called the law firm to say I was going to be a bit late because I had a flat tire. And then I showed up half an hour later than I was supposed to be when I got back. And they were like, wow, AMA came real fast. Like the tow truck came real fast. And I was like, it's a flat tire, my dude. I just put on the spare. Like that was not worth calling the tow truck over and waiting like 6 hours because that's how long it can be to like you just do it. And they were just so flabbergasted by this notion that I could change a tire. It's not even hard, folks. And if you don't know how to change a tire, practice changing a tire. It's the sort of thing to practice doing when you're not like under pressure. Just practice doing it. So yeah, just whatever. But the other thing is, I think that this is written in a fashion that is a bit overwrought, a bit over panicky, a bit over frightened and over scared and over all of this, I don't think it's unreasonable that they are concerned about what people might do to them if their name is out there. I don't think it's going to be somebody taking a tire iron to their face. I don't think it's going to be anything like that. But it might be somebody showing up at their workplace to yell at them. Some crazy person wants to yell at them and shows up at their workplace. It might be that that somebody calls them and makes threatening remarks. It might be that somebody, all of these things, right? So just, I think it's reasonable to have, some of the people who are on Twitter have been shitty to me just for covering this case. And I mean, I'm a big boy. I don't mind if somebody's being shitty, but not everyone is there. Allison says you can get a backflow preventer for your sewer line. It has a gate that floats up and seals off the sewerage backflowing in. Here's the fun thing. I have one. I have a backflow preventer. The pressure that caused that sewage backup was sufficiently high pressure that it blew up my backflow preventer. My backflow preventer got destroyed by the sewage leak. So it did not do the thing. Was it tree roots? No, it was the main sewer line got blocked down the road, and there was a lot of pressure. So it just it was a major thing there. So yeah. I'm internally anxious the vast majority of the time, but come emergency, my anxiety is like, this is what we've been preparing for. There's a lot of people who are like that, super anxious right up until they need to. And yeah, so, all right. Yeah, those should come with insurance like surge. The good thing is we have insurance, but the bad thing is, yeah. Oh no, so multiple homes got it. Yes, absolutely multiple homes got it. The entire block had people. Also, because Mrs. Runkle and I are on the ball about like dealing with things when disasters happened, we got one of the first claims in with our insurance company, and they're like first come first serve. So we had the maintenance and repair people there, whereas other people were waiting for like a week. And let me just tell you, with a sewage backup, it has a smell. There is an odor to it. So there is a smell. And as Attorney Tom likes to say, insurance is a scam. Here's the thing. Our insurance was actually really good. Our insurance stepped up with getting the remediation companies in there. Our insurance paid money, paid out. There was no problems. We had a great experience with our insurer. Was fantastic. So yeah. All right. So that is what we've got there. Somebody was like, which lawyer filed this? It's an Andrew P. DeCenzo. I don't know who Andrew P. DeCenzo is. I don't know who who that is. And Fancy RPG says, yeah, but Runkle, you have a Canadian insurance company. They're less shady. Absolutely, I agree. Oh, by the way, I should have a new Runkle of the Bailey video, or not Runkle of the Bailey, Roll of Law video coming out tomorrow, I hope. Do you think we can draw any conclusions from the comment on witnesses testifying about harassment? Does it sound as though it had any impact on the jury? A little bit in terms of making the jury concerned. I don't know that it changed their verdict one way or the other. So, now I don't have a good, now I'm just trying to pull up the, I'm trying to find a good source for a readable, what do you call it? Like a readable version of this, of the ruling, because there is the ruling on this one, and the ruling, here we go. It's on Reddit. It's not fantastic. It's going to be hard to read, but we'll try to bring it up here just so that we can see it. So, yep. Let me just see if we can embiggen this or not. Okay, we can a little bit. We're going to present this. Share screen. All right, let's try to get all of the images here. Okay, we're going to share the screen. Wow, that is so not helpful. Okay, that's a little better. Findings and order on Juror Doe's emergency motion to extend July 8th, 2024 impoundment order. This is the ruling. This is what happens. This is the verdict. Harstem Harshmuck. I have no. It seems like tadpole at the end. I just don't even have a first clue of how to pronounce that. So, all right. Findings in order. This matter came before the court on the emergency motion of Juror Doe to extend the order entered by this court. Upon review of the motion and supporting documents, the court makes the following findings and order. 1. This case has garnered significant and divisive attention in Massachusetts and across the nation. 2. Individuals associated with this case have been charged with intimidation, which charges remain pending. 3. Juror Doe has submitted a detailed affidavit, which I find to be credible. I find it to be credible. I just find it to be overwrought, right? So, yeah. Juror Doe is in reasonable fear for their safety and the safety of their family if the list of jurors is made available to the public. I do find that they have a reasonable fear. I think that it's a little overwrought, but I think that it is still a reasonable fear once you strip that out. So, through the affidavit, Juror Doe has established that publication of the list identifying the names of the impaneled jurors will present a real and present risk of personal harm to jurors and to the integrity of their service. And through their affidavit, Juror Doe has established that there is a continuing risk of immediate and irreparable injury should the jury list be made available to the public at this time. Through their affidavit, Juror Doe has established good cause to extend the impoundment order until and unless otherwise ordered by the court. So the impoundment order is extended indefinitely. Basically, until the court says otherwise, this continues. This order shall not preclude any juror from identifying himself or herself and/or speaking to the public about his or her jury service. So the jury can talk if they want, but the jury doesn't have to talk. And the jury can't be identified, like that can't be released. Okay, now the other question lots of people have been having is, how does this affect Karen Reed's effort to get those 2 charges thrown out? Well, I can say that it probably doesn't affect it a whole lot. And the reason why is because they just want affidavits from those 3 jurors. And this order doesn't actually prevent them from speaking to those jurors because those jurors already reached out. The other thing is they can, if they need to, apply for an extension or sorry, an exception or a variation or whatever else, right? That is also doable. They can apply to change this. And so I don't think this matters all that much. I think this is actually, I think that this is actually reasonable. I don't think this is crazy to impose this. I think the juror is a little overly anxious, but I mean, fair enough. I don't live in Canton. I don't live in, and thank God for that. But I don't live in Canton. I don't know. Like, I don't know how tense it is there. I suspect it might be a little more tense already. So, whew, that's getting spicier. Whoa. I don't think the judge, and here's the thing the judge has to consider. Let's say the judge says, hey, I am going to release the names anyway. We're releasing the names. And so the public gets the names, right? Everybody in the public gets the names. And then 2 days later, 2 days after that happens, what is the next thing someone does? Well, some crazy person shoots a juror in the face. Do you think Bev wants to risk having like released the names and then against the wishes of the jury, and then a crazy person takes out a juror? Do you like? Obviously, the judge is going to be cautious under these circumstances. I think that it was very, very likely that the judge was going to be was going to approve this because, yeah. Somebody said, did the spice settle? Yeah, it's actually, I think I may have put too much spice in this and kind of ruined it because it now is like drinking hot sauce, except it's not as tasty as drinking the hot sauce. The hot sauce tastes better. So I've opened a backup drink, and I think I may pour this one out because, yeah, I think I ruined it for myself. It's like drinking hot sauce now, and but it tastes worse than drinking hot sauce. So I think it is reasonable for the judge to do this. I know there's some people online who are just like super, super big mad about this. And I'm not one of them. I don't think this is crazy. And the judge, of course, can change this. The judge, of course, can later amend this. If things settle down a bit, or if there's better evidence or whatever else, I don't think it's crazy. I don't think it, like, this doesn't bother me at all. All right. Oh, and Sophie wanted to say good night. Good night, Sophie. All right, let's go through some super chats here. Efferhild 66, love watching Runkle live. Glad to have you here. Amy's Positive Pathways, thank you for joining up. That sounds like a relaxing channel. Githralkin, the judicial system is necessarily not personal. Yep. Laura Riker, please help define what's so icky about this. I don't think this is icky. I think if I was on the jury, I would make the same application. And I say this as somebody who's currently making an application with a court to have some of my private stuff held out. Now, I think that we still don't know if a retrial is necessarily going to happen. And I think as time goes on, the likelihood of a new trial diminishes. We have Lally saying we are definitely going to have a new trial. Definitely going to have a new trial. But the problem is that their case keeps getting worse. And one of the things that's gotten really, really worse about their case is that Proctor, I mean, his career has basically, his career is like basically like that sewage flood that happened in my basement, except it's also on fire. And also, like, the sewage is full of like dirty syringes. So, you know, case is getting real bad. Case is getting real awful. And yeah, I'm hoping that I'm hopeful that they just let it go. I'm hoping that they just let that go. So yeah, that's about it. Any questions before we wrap up? Any questions here before I see? What protection does the jury have from attendees of the trial who can identify them? I was never comfortable with how Brian Albert sat and stared at the jury during closing. They should not be publishing that. Whose career is a bigger mess, Lawley or Morrissey? I don't actually know that either of them is having too many career problems. Morrissey's going to do just fine as a defense lawyer. People are like, oh, they added her to the Brady list. Okay, maybe she doesn't do any prosecution work anymore. Lally, it's like, oh, Lally is, I don't like him as a lawyer, but he's doing just fine. Like a decade ago, Lally got some award for being an awesome, for being an awesome prosecutor. So, yeah. Did I cover the 5th juror affidavit? Yes, I did. That was at the early beginning of this. Proctor's now busy blaming people for his kids possibly losing their health insurance. The man is unbelievable. The person to blame for that is Proctor. Person to blame for that is Proctor. Which one is the worst prosecutor? Oh, yeah, this is a good question. Which Morrissey? I keep forgetting that there's the Morrissey in Massachusetts. I assume that I don't like the Morrissey in Massachusetts. I watched his interview where he talks about the case. His interview where he talks about the case has, so yeah, I did not like that at all. But if you mean the New Mexico one, the New Mexico Morrissey is going to be fine, right? New Mexico Morrissey is going to be just fine. Yeah. Yeah, they tried to claim that Unetti was involved in witness intimidation. There was no evidence of that. Yeah, it's Fancy RPG. What is your favorite color? My favorite color is kind of a weird thing. So, I am slightly, but not very, colorblind. Slightly. And so there are certain colors that if you blend it just right, my brain doesn't know how to decide what they are. And so that can be absolutely fascinating because it's like there's a shade of blue that my brain will decide is blue, green, blue, like, or not blue, green, blue, gray. And that particular shade of blue would be my favorite color because it is fascinating watching my brain reassess over and over and over again what color that is. Just by, like, when I was a teenager, my mom, I was moving from one room to another and sort of setting up a room. And so my mom was like, which color of paint of these colors of paint do you want to have your room painted in? And one of them was that color. So I had my entire room painted in a color that messed with my brain, because that is just kind of the that's kind of just the way I do things. So yeah, it was fun. It was a fun thing. So yeah. Yeah. Show it like on, I'd have to fiddle around. I can't do it right away. I'll try to get it done for like a Monday fun day thing. I'll try to get like the Pantone name, somebody saying, or the hex code. I'll try to get that for like a Monday fun day. I'm just not going to be able to find it right away. So yeah. Ian's 24-page explanation for what his favorite color is. Have you taken the Ishihara test? Is that one of the color blindness tests? Is that one of the color blindness? Yes, I have. Now, I just want to note that so at one point, I wanted to go to Mars. At one point, I wanted to go to Mars with the Mars One project. And so one of the things that they had as one of their principles was that you can't be colorblind. And the thing is I'm not very colorblind. I'm a little tiny bit colorblind, but it'll show up on the test. And so what I was getting set to do, I was getting set to Gattaca the hell out of that. And what I mean by Gattaca the hell out of it is I was memorizing the Ishihara test. I was memorizing the color plates to know what the correct number was. And so I was getting all set to go get my color blindness test and so I was going to sit there and I was just going to nail the test because it was straight up I was just going to straight up memorize it. And then they would send in a certification that my color blindness was just fine. Because I was just gonna do that. Then ultimately that whole project fell through. So, and I was not selected as a thing there. So yeah, but yeah, that was gonna be fun. So, but then what happened? Then they didn't select me, and then the project got canceled. So yeah. All right. So that I think is sort of all of that. I think we've covered all of that one for today. So we will wrap this up. Oh, there's another super chat that I missed. Oh, it is the what is your favorite color? There should be a Role of Law video coming out, tomorrow, I'm hoping. And yeah. Yeah. Sounds like you were taking the route of some famous naval officers from World War II. Cheat on the eye exam, because why not? Absolutely. I was totally going to do that if I could. The thing is I started studying, like trying to memorize those things before I was, when I was still just at the initial application. And that was because I knew that if I made it to round 2, that I was going to have a short time limit to do the color blindness test. So I wanted to be ready with the memorization and all of that. So, yeah. All right. Runkle, will you cover Bowles' interview, please? Not tonight. I will cover it another time. So I will cover another time. You should make your favorite color into an emoji. I guess I could do that. Yep. What is your most hated color? That sort of baby puke yellow brown, or baby poop yellow brown, is probably the most hated color. All right. I'm going to sign off for today. We can probably go over the Bowles interview on Monday. Maybe Saturday, maybe Sunday. Maybe that. We'll figure that out, and we'll go from there. So, but for tonight, we've sort of covered this, and we will go there, or we'll go there. Not mustard. Mustard is a nice yellow. It's the brown baby poop. Like, brown baby poop is a terrible color. So yeah, that is the worst. All right, we're gonna roll the outro before I get too distracted, and I will see you guys soon.